consideration. Part of having a judicial philosophy is having an understanding of the fundamental principles of our Constitution. Natural rights are a part of that system. Judge Jackson explained to us that she does not, quote, hold a position on whether individuals possess natural rights. Now that ought to be very shocking. Natural rights are basic to our constitutional system and principles of limited government, because we all know our country was founded on the belief that's expressed in the Declaration of Independence: all men are created equal, and they are endowed by their Creator with certain unalienable rights. Among these are the life, liberty, and the pursuit of happiness. And that was further nailed down in the Constitution of the United States. Our Constitution vests the three branches of government with very limited power. All other powers not given to the federal government are reserved to the states and to the people thereof. The principle of limited government is what makes America an exceptional nation and sets our Constitution apart. Judges must have a proper understanding of those basic principles, and the way Judge Jackson answered those questions, particularly the answers she gave to Senator Cruz, shows that she lacks that very necessary foundation. Now I want to go on to a few other examples. At the hearing, Judge Jackson testified about one of her decisions involving the First Step Act. In that case, prosecutors had rock-solid evidence against a dangerous drug kingpin. But Judge Jackson was displeased the government pursued a mandatory minimum sentence. So she misused a motion for compassionate release to resentence that person to a sentence she thought he deserved. As the lead author of the First Step Act, I know that's not what we wrote the statute to do. The act was supposed to allow elderly inmates and those suffering from terminal illness to petition the court for a sentence reduction. The statute also allows for a reduction if the court finds an extraordinary and compelling reason. Judges should use great discretion. Judges should weigh against the charge the dangers to society and the risk of recidivism. At her hearing, Judge Jackson said that she based her extraordinary and compelling finding on the non-retroactive changes to the law. This radical interpretation is terrible and dangerous. Congress chose which provisions of the First Step Act would apply retroactively. The Senate is currently considering legislation that I co-sponsored with Chairman Durbin that makes some of the First Step Act provisions retroactive. But that's Congress's role, not Judge Jackson's role. Senator Durbin and I wouldn't have been able to broker a compromise on that legislation if senators thought the judges would rewrite the law and insert their own views from the bench. Decisions like this will make bipartisan work, particularly on criminal justice reform, harder to do. That case by the name of Young is just one example of Judge Jackson's lenient approach to criminal law and sentencing. She also declined to apply a number of sentencing enhancements that Congress put into the sentencing guidelines. A case by the name of Make the Road New York versus McAleen is another case that shows how Judge Jackson used her methodology to reach a result that contradicts the plain text of the law. Congress gave the Secretary of Homeland Security, and these are the words from the law, sole and unreviewable discretion to decide whether illegal immigrants should be subject to expedited removal within 2 years. Judge Jackson reviewed the agency's decision anyway, and it seems clear why. She went out of her lane to comment on the policy as, in her words, a terrible proposal. And she claimed that the government attorney made an argument that reeks of bad faith. Reeks of bad faith are her words. In fact, her decision and her rhetoric are unfounded. So that's why her decision earned a strong rebuke from the panel of liberal and conservative judges when she was reversed by the D.C. Circuit. Judge Millett, an Obama appointee, explained it this way in the opinion, quote, "There could hardly be a more definitive expression of congressional intent than sole and unreviewable discretion." These are just a few examples of Judge Jackson's judicial activism, because her record clearly shows she does not believe in or act within the limited and proper role of a judge. So I will vote against her confirmation. I yield the floor.
Mr. President.
Senator from Illinois.
Mr. President, this Capitol building has served as the backdrop for some of the most notable moments in America's history. In this building, wars have been declared, peace treaties have been signed, and the march toward progress has either moved forward or has been stopped in its tracks. Today, the members of this Senate have the opportunity to take a monumental step forward. We will vote to confirm a once-in-a-generation legal talent, a jurist with outstanding credentials and a lifetime of experience, and the first ever African-American woman to serve as Justice of the Supreme Court, Judge Ketanji Brown Jackson. Judge Jackson's confirmation will be a glass-shattering achievement for America. Consider this moment in history. When the Supreme Court first met in this building in February of 1801, there were 1 million slaves in this nation, a nation of 5 million people. This very building was built with the labor of enslaved people. And at the time the court met, neither black Americans nor white women had a constitutionally guaranteed right to vote. Women had no place in that first Supreme Court chamber, and black women would only enter to clean it in the dark of the night. We know what followed. America's battle to end slavery saw a bloody civil war, decades of efforts to break down racial barriers, and the efforts continue to this day. And our struggle to enfranchise and empower women did not end with the 19th Amendment 102 years ago. It continues to this day as well, as we strive to give our daughters the same opportunities we give our sons. This confirmation of the first black woman to the Supreme Court honors the history that has come before it. It honors the struggles of the past, of the men and women who waged them. And this confirmation draws America one step closer, one step to healing our nation, one step closer to a more perfect union. Nearly a century after our founding, we guaranteed the rights of citizenship finally to every American, including for the first time those who were born into bondage with the ratification of the 14th Amendment. It took a long century later for us to expand the bounds of liberty again. We ensured the federal government could vigorously protect the right to vote, the most fundamental of rights, with the passage of the Voting Rights Act of 1967. One victory for progress begat the next. 2 years after the Voting Rights Act, we confirmed the first Black American to ever serve on the Supreme Court, Justice Thurgood Marshall. But I'd like to remind you, that was 50 years ago. Now, with the passage of that time, we are beginning to write another chapter in our nation's quest for equal justice under the law. And that chapter begins with 3 letters, KBJ. With Judge Ketanji Brown Jackson's confirmation to the highest court in the land, we are not only making history, we are carrying on a great American tradition, elevating one of our nation's best and brightest legal minds to an honored position of service. There's no one more deserving of this high honor. As we've learned over the past month, she is the best of us. She has devoted her life to serving our country. She's done so at every level of the federal judiciary, and at every turn she's distinguished herself. When I hear the critics say she's soft on crime, I wonder how they explain that she was endorsed by the largest law enforcement agency and organization in America, the Fraternal Order of Police, as well as the International Chiefs of Police, as well as an army of federal prosecutors who have appeared in her courts. She's dedicated to protecting judicial independence, to advancing freedom and liberty, and deciding every case, as she says, from a neutral posture. That's exactly what you'll find in evaluating nearly 10 years of service on the bench. I hear senators come to the floor and say, well, there's one opinion I disagree with. For goodness sakes, she's issued almost 600 written opinions in 10 years on the bench in the district court. She's been reversed a small percentage of the time. Her work speaks for itself. And when you evaluate it, you'll find out she's thoughtful and even-handed. As the American people saw during last month's hearing in the Judiciary Committee, Judge Jackson has the right judicial temperament. Calm, collected, she answered every question, even when the questions were hostile and confrontational. She answered them with dignity and grace and stood by for more than 24 hours of questioning. She's a proven consensus builder. She's been confirmed by the Senate on a bipartisan basis more than three times, I should say, and soon we hope she'll be confirmed again by a bipartisan majority. She's earned the support from leaders across the political and ideological spectrum, civil rights leaders, leaders in law enforcement, former federal judges appointed by Democrats and Republicans. All of them have lined up proudly to endorse her. Perhaps most importantly, Justice Jackson will help ensure that the law works for the people and that the people understand the workings of the court. For many Americans, what happens in a courtroom can be cold and impersonal. Judge Jackson has made a habit of making it real. She looks people in the eye, walks them through her decision-making with patience and empathy, and she reaches every one of her decisions by following the facts and the law wherever they lead. She said that her opinions can run long. That's by design, because she wants America to rest assured, whether she writes in the majority, the concurrence, or dissent, they want to know exactly where she stands on the most important issues. Serving as chair of the Senate Judiciary Committee during Judge Jackson's confirmation has been one of the highest honors of my Senate experience. I want to give special thanks to the man who spoke before me, Republican Senator Chuck Grassley of Iowa. His friendship and fairness have really guided our relationship throughout this historic process. In the weeks since President Biden announced her nomination, Judge Jackson has already lifted the spirit of countless Americans, inspiring a new generation of aspiring jurists and public servants. Millions of Americans see themselves in Judge Jackson. Black Americans, members of law enforcement families, working moms, public high school graduates, like her fellow Palmetto Panthers in Florida. Everywhere I've gone for the last few weeks when I go home, visiting law schools, going to the grocery store, I've been approached by people who've been following this nomination closely. They tell me how deeply impressed they are with Judge Jackson, even under fire from her critics. Hannah Edmondson is one of those people. She's a law student in Waukegan, Illinois, a city on the shores of Lake Michigan. In a letter to my office, Hannah wrote, and I quote her in saying, "If you can see it, you can be it." And I'm very excited to see America's first black female justice. Reverend Krista Alston is a Baptist minister in the city of Chicago. Comes from a long line of Baptist ministers. She calls herself a civil rights baby. Born in '64, the year LBJ signed the Civil Rights Act. Ricky Jones is also from Chicago. She's been working for civil rights for nearly 60 years, since she was a teenager. Well, late last month, Reverend Alston and Miss Jones, with 4 other people, drove 11 hours from Chicago to attend an hour of Judge Jackson's hearing. Reverend Alston said she was moved by the judge's courage, grace, integrity, and wisdom. She imagined what it will be like years from now to tell her future grandchildren what it was like to be in that room for that historic moment. And Ricky Jones said she never even expected to hear about a black woman being nominated to the Supreme Court, let alone to be in the room for her hearing. She said as she watched Judge Jackson, "It felt like the fulfillment of everything I've worked for my whole life." She thought of all the strong black women who came before her and helped make the movement possible. Sojourner Truth, Harriet Tubman, Ida B. Wells, and my personal late friend, the Reverend Willie Barrow, a black woman minister from Chicago who worked alongside Dr. Martin Luther King. This moment was about them too, she said. And this moment is possible because of Judge Jackson and who she is, her qualifications, her integrity, her record of excellence. She has earned her seat on the Supreme Court. That's why it's so unfortunate that several Republicans on the Judiciary Committee did not approach Judge Jackson's hearing with that same level of fairness and respect as their colleagues. Thankfully, there are members of the Senate who are willing to rise above the partisan fray. I want to particularly commend Senator Susan Collins of Maine, Senator Lisa Murkowski of Alaska, and Senator Mitt Romney of Utah for their political courage and their willingness to support a singularly qualified and historic nominee to the Supreme Court. You know, when Senator Romney announced his support for Judge Jackson's confirmation, I couldn't help but remember his father, the late George Romney, who served as governor of Michigan in the 1960s during the height of the civil rights movement. Governor George Romney knew a thing or two about political courage. As a proud Republican governor in 1963, he marched alongside of the NAACP Detroit president, Edward Turner, in support of civil rights. That same year, when Dr. Martin Luther King organized a march in Detroit, Governor George Romney declared the occasion Freedom Day in Michigan. To my colleague, Senator Mitt Romney, you are your father's son. This week marks 54 years since the shot rang out in Memphis, Tennessee, claiming the life of Dr. Martin Luther King, an American who spoke with greater moral clarity than nearly any other in our history. The night before he died, Dr. King spoke at a rally in support of the city's striking sanitation workers. There was tension in the air. From the moment he set foot in Memphis, he'd received a barrage of death threats. And as Dr. King spoke to the crowd at the Mason Temple, death was on his mind. He said, "Like anybody, I'd like to live a long life. Longevity has its place, but I'm not concerned about that now. I just want to do God's will, and he's allowed me to go up to the mountain." His next words proved prophetic. Dr. King said, "I've looked over and I've seen the promised land. I may not get there with you, but I want you to know tonight that we as a people will get to the promised land." Ricky Jones said that she thought about Dr. King's prophecy when she realized the Judiciary Committee was voting on Judge Jackson's nomination on the anniversary of Dr. King's death. It felt like the prophecy had come to pass. Dr. King didn't make it to the promised land, but Judge Jackson's ascension to the Supreme Court brings us closer to that longed-for place. I'd like to close with one last personal plea to my Senate colleagues. I hope you'll think about this. In the years to come, long after we've left the Senate, one of our grandchildren may ask where we were on this historic day, April 7th, 2022, when America broke down what seemed like an impossible racial barrier and voted to send the first African-American woman to serve on our highest court. I will be proud to say I was on the Senate floor, standing at my desk and casting my vote with pride for the next Associate Justice of the Supreme Court of the United States, Justice Ketanji Brown Jackson. I hope my colleagues will join me in sharing this historic moment. And I yield the floor. The absence of quorum.
Clerk will call the roll.
Ms. Baldwin.
Mr. President,
Republican leader, we are in a quorum call.
ask consent that further proceedings on the quorum call be dispensed with.
Without objection.
President Biden was elected on the promise that he would govern as a moderate and unite the country. He insisted the radical left would not be calling the shots.
Please. Senator will commence.
He insisted the radical left would not be calling the shots on his watch. But when it came to one of the most consequential decisions a president can make, a lifetime appointment to our highest court, the Biden administration let the radicals run the show. With Washington Democrats in power, the far left got the reckless inflationary spending they wanted. The far left has gotten the insecure border they wanted. And today, the far left will get the Supreme Court justice they wanted. The fringe activists who demand partisan court packing, attack the justices, and describe our Constitution as trash made up their minds from the start of this administration. If a Supreme Court vacancy should arise, they wanted one nominee and one nominee only, Judge Jackson. They spent dark money to promote this person specifically. They pushed her for the D.C. Circuit. Then they badgered Justice Breyer to quit. In February, one of these groups announced Judge Jackson would be the nominee before President Biden actually did make the announcement. So think about that for a moment. The Senate has examined Judge Jackson's qualifications with the seriousness and vigor that a lifetime appointment deserves. Unlike when the parties' positions are reversed, the country was not subjected to uncorroborated smear campaigns, committee boycotts, stunts with cardboard cutouts, or mobs chasing senators around the Capitol. Now, a few of our Democratic colleagues seem to have decided in advance they would claim that Judge Jackson was treated shabbily. I've heard that script recited, even though it didn't happen. Didn't happen. Let's be clear. No nominee before the Senate for any position deserves a cakewalk or a coronation. Tough questions about a federal judge's own rulings and statements are the definition of fair game. My Republican colleagues vigorously inquired, shed important new light on a frequently disturbing judicial record. So I applaud my colleagues for focusing on substance and not following the Democrats' recent precedents into the gutter. Unfortunately, what the Senate's process turned up was disturbing. First, the nominee would not follow the Ginsburg-Breyer precedent and denounced the insane concept of partisan court packing. Second, her judicial record is full of cases where Judge Jackson ruled like a policymaker implementing personal biases instead of a judge following the text wherever it led. And third, her aggressive judicial activism frequently focused on treating convicted criminals as gently as possible. In literally case after case, from deadly fentanyl to open borders to child exploitation, Judge Jackson tilted the scales of justice away from public safety and innocent victims in favor of her career-long passion for softening up criminal sentencing. In Judge Jackson's courtroom, plain legal text and clear congressional intent were no match for what the judge admits are her personal policy disagreements. Even as a violent crime wave sweeps America, Democrats are pursuing a nationwide campaign to make the justice system softer on crime. They're stacking the deck with far-left prosecutors, woke warriors at the Department of Justice, and federal judges who believe criminals deserve lighter treatment. This project is terrible for innocent American families, and every piece of evidence suggests Democrats view Judge Jackson as its crown jewel. So I'll close with this. These debates about judicial philosophy are not just academic. The charged political atmosphere around confirmations, the outsized role that unelected judges play in our national life, these are direct consequences of liberal judicial activism. They're direct results of the efforts to misuse federal courts as a progressive legislature that voters can't kick out. A republic of self-serving citizens should not spend every June watching with bated breath to see if 5 or 6 lawyers will hand down sweeping policy changes with zero basis in the written Constitution. And the solution is not to make the court even more of a super legislature like liberals want, a delegitimizing death spiral that would destroy the rule of law. There's only one solution: The Senate should only confirm justices who will follow the text of our laws and our Constitution wherever it leads, who will leave subjective policy judgments on this side of the street where they belong. That's how we lower the temperature. That's how we shore up the courts. That's how we protect the rule of law. Staff the judiciary with brilliant men and women who understand and embrace this limited role. No other road leads anywhere good for our great nation.
Mr. President.
Majority Leader.
Mr. President, this is a wonderful day, a joyous day, an inspiring day for the Senate, for the Supreme Court, and for the United States of America. Today, we are here to vote to confirm Ketanji Brown Jackson as the 116th Justice of the United States Supreme Court. Now, a few days ago, I spoke with a group of 8th graders from Cheektowaga, New York. Many of them were students of color. It was amazing. When I mentioned that this week we were confirming the judge, you could see them light up, the unmistakable look in their eyes. One day, each young lady thought to herself, I can do it too. You know, it's been a dark 2 years with COVID. People getting sick and dying, many of whom we knew, stores closing, schools shutting their doors. But even in the darkest times, there are bright lights. Today is one of the brightest lights, and let us hope it's a metaphor, an indication of many more bright lights to come. As I've said over and over again, there are 3 words that I think best fit Judge Jackson: brilliant, beloved, belongs. Judge Jackson is in every sense and by all measures a brilliant jurist. She is indeed a brilliant person. By the judge's own telling, she first discovered her calling to the law not in a classroom or by reading a book or by talking to lawyers, but by sitting at the kitchen table next to her dad, filling out her coloring book while her dad poured through case law. Years from now, other parents and other daughters will do the same, and it will be Justice Jackson's opinions that will lay open on the table. The judge's parents, her entire family, should beam with pride that this day has come. At every step of her upbringing and career, Ketanji Brown Jackson ranked among the highest of achievers. And look, we should take a moment to note that Judge Jackson will be the first and only justice with experience as a public defender. We're proud of that, and America is proud of that. It will enhance the court's ability to preserve a basic truth in our country, that all deserve equal justice under the law, from the privileged to the impoverished. In an imperfect world, the judge conquered so many hurdles, and today stands as one of the most experienced individuals ever nominated to the Supreme Court. For this reason, the judge is also beloved by individuals and organizations across the political spectrum. I went through her record carefully, and never did I find one instance of a peer or colleague or associate say one negative word about her. It was incredible. When we go through these records, you often find someone here and there who will badmouth the individual who knew them. Not with just Judge Jackson. And lest we forget, the judge is popular in the minds of the American people, A Gallup poll released after her hearing showed nearly 60% of the public supports her confirmation, 10 points above the historical norm. And there is no question here, the country by and large wants the Senate to confirm Judge Jackson. Police chiefs want to confirm Judge Jackson. Conservative and moderate and liberal judges all want us to confirm Judge Jackson. And I thank my colleagues in this chamber who worked in good faith to make sure the Senate can finish its work today. Finally, as I've said many times, the judge belongs on the Supreme Court. By that I mean something very specific. In our nation's history, 115 individuals have been confirmed by this body to serve on the Supreme Court of the United States. Of those, 108 have been white men. Only 4 have been women. Only 2 have been African American. But Ketanji Brown Jackson will be the first African American woman ever to hold the title of justice. Think about the impact that will have on our democracy. Untold millions of kids will open textbooks and see pictures of Justice Jackson among the highest ranks of our public figures. How many millions of kids in generations past could have benefited from such a role model? How many would-be justices, lawyers, doctors, generals, business people have been lost to history precisely because their history books had few, if any, role models that they could relate to? We certainly have a long way to go on the road to true justice, but by confirming Judge Jackson today, we are taking a bold step forward towards reaching the full realization of our country's promise. We will make it far more likely that girls across America will feel precisely what Judge Jackson felt herself when she was a kid. Nobody can stop me. I can do this too. I am brilliant too. I belong too. For all these reasons, increasing the diversity of the court has been one of my highest priorities and one of the highest priorities of our Senate Democratic majority, of whom I am so proud. Justice Jackson is the most important example, but we've been working on this for over a year. Of the 58 Senate-confirmed federal judges since we took the majority, 3/4 have been women. 2/3 have been people of color. And it's not just racial and gender diversity that matters. We have strived to lift up judges that bring diversity through their experience. More public defenders in our courts, more civil rights lawyers, more election lawyers. When Americans of all walks of life come before the court, they should have confidence that those who don the robes have the ability to walk in their own shoes, to see and understand their side of the story, and then apply the law properly according to the facts. One judge at a time, one judge at a time, this majority is expanding the possibility of who merits consideration to the bench. And I would be remiss if I didn't acknowledge my Republican colleagues who joined us on this occasion over the year to achieve this goal. In closing, I want to thank Chairman Durbin for beautifully executing this nomination process. It was equal parts fair, thorough, and expeditious. No easy feat in this modern Senate. I want to thank all of my Democratic colleagues on the Judiciary Committee. You were just fabulous, every one of you, for your respectful and insightful examination of the judge's record. And I want to thank my Republican colleagues who chose to take this process seriously, no matter which side you voted on. The President sent us an impressive nominee. She merited a robust and thoughtful and lively examination. I thank the members who did it precisely that. In short, Madam President, this is one of the great moments of American history. At the time of our Constitution's ratification, in most states you had to be a white, male, Protestant landowner to be considered part of American society. So from the get-go, generations of Americans have sought to establish the United States as a full democracy. We fought a bloody civil war to end slavery. Women organized and reached for the ballot. The civil rights movement brought an end to the vicious segregation of the mid-20th century. And today, we are taking a giant, bold, and important step on the well-trodden path to fulfilling our country's founding promise. This is a great moment for Judge Jackson, but it is even a greater moment for America as we rise to a more perfect union. I thank my colleagues for their work, and I yield the floor.
Under the previous order, all post-cloture time has expired. The question occurs on the nomination of Ketanji Brown Jackson of the District of Columbia to be an Associate Justice of the Supreme Court of the United States.
I ask for the yeas and nays.
Is there a sufficient second? There is, and certainly appears to be, a sufficient second. The clerk will call the roll.
Ms. Baldwin. Aye. Ms. Baldwin, aye. Mr. Barrasso. No. Mr. Barrasso, no. Mr. Bennett. Aye. Mr. Bennett, aye. Mrs. Blackburn. Mrs. Blackburn, no. Mr. Blumenthal. Aye. Mr. Blumenthal, aye. Mr. Blunt. No. Mr. Blunt, no. Mr. Booker. Yes. Mr. Booker, aye. Mr. Bozeman. No. Mr. Bozeman, no. Mr. Braun. Mr. Braun, no. Mr. Brown. Aye. Mr. Brown, aye. Mr. Burr. Mr. Burr, no. Ms. Cantwell. Aye. Ms. Cantwell, aye. Mrs. Capito. Mrs. Capito, no. Mr. Cardin. Aye. Mr. Cardin, aye. Mr. Carper. Aye. Mr. Carper, aye. Mr. Casey. Aye. Mr. Casey, aye. Mr. Cassidy. Mr. Cassidy, no. Ms. Collins. Aye. Ms. Collins, aye. Mr. Coons. Aye. Mr. Coons, aye. Mr. Cornyn. No. Mr. Cornyn, no. Ms. Cortez Masto. Aye. Ms. Cortez Masto, aye. Mr. Cotton. No. Mr. Cotton, no. Mr. Kramer. No. Mr. Kramer, no. Mr. Crapo. No. Mr. Crapo, no. Mr. Cruz. Mr. Cruz, no. Mr. Daines? No. Mr. Daines, no. Ms. Duckworth? Aye. Ms. Duckworth, aye. Mr. Durbin? Aye. Mr. Durbin, aye. Ms. Ernst? No. Ms. Ernst, no. Mrs. Feinstein? Aye. Mrs. Feinstein, aye. Mrs. Fisher? No. Mrs. Fisher, no. Mrs. Gillibrand? Aye. Mrs. Gillibrand, aye. Mr. Graham? Mr. Grassley? Mr. Grassley, no. Mr. Haggerty? No. Mr. Haggerty, no. Ms. Hassan? Aye. Ms. Hassan, aye. Mr. Hawley? No. Mr. Hawley, no. Mr. Heinrich? Aye. Mr. Heinrich, aye. Mr. Hickenlooper? Aye. Mr. Hickenlooper, aye. Ms. Hirono? Ms. Hirono, aye. Mr. Hoven? No. Mr. Hoven, no. Mrs. Hyde-Smith? No. Mrs. Hyde-Smith, no. Mr. Inhofe? Mr. Inhofe, no. Mr. Johnson? No. Mr. Johnson, no. Mr. Kane? Aye. Mr. Kane, aye. Mr. Kelly? Aye. Mr. Kelly, aye. Mr. Kennedy? No. Mr. Kennedy, no. Mr. King? Aye. Mr. King, aye. Ms. Klobuchar? Aye. Ms. Klobuchar, aye. Mr. Langford? Mr. Langford, no. Mr. Leahy? Aye. Mr. Leahy, aye. Mr. Lee? Mr. Lee, no. Mr. Lujan? Mr. Lujan, aye. Ms. Lummis? Ms. Lummis, no. Mr. Manchin? Mr. Manchin, aye. Mr. Markey? Mr. Markey, aye. Mr. Marshall? Mr. Marshall, no. Mr. McConnell? Mr. McConnell, no. Mr. Menendez? Mr. Menendez, aye. Mr. Merkley? Mr. Merkley, aye. Mr. Moran? Mr. Moran voted in the negative. Ms. Murkowski? Ms. Murkowski, aye. Mr. Murphy? Mr. Murphy, aye. Mrs. Murray? Mrs. Murray, aye. Mr. Ossoff? Mr. Ossoff, aye. Mr. Padilla? Aye. Mr. Padilla, aye. Mr. Paul? Mr. Peters? Aye. Mr. Peters, aye. Mr. Portman? Mr. Portman, no. Mr. Reed? Mr. Reed, aye. Mr. Risch? Mr. Risch, no. Mr. Romney? Mr. Romney, aye. Ms. Rosen? Ms. Rosen, aye. Mr. Rounds? Mr. Rounds, no. Mr. Rubio? Mr. Rubio, no. Mr. Sanders? Mr. Sanders, aye. Mr. Sass? Mr. Sass, no. Mr. Schatz? Mr. Schatz, aye. Mr. Schumer? Mr. Schumer, aye. Mr. Scott of Florida? Mr. Scott of Florida, no. Mr. Scott of South Carolina? Mr. Scott of South Carolina, no. Mrs. Shaheen? Mrs. Shaheen, aye. Mr. Shelby? Mr. Shelby, no. Ms. Sinema? Ms. Sinema, aye. Ms. Smith? Ms. Smith, aye. Ms. Stabenow? Ms. Stabenow, aye. Mr. Sullivan? Mr. Sullivan, no. Mr. Tester? Mr. Tester, aye. Mr. Thune? Mr. Thune, no. Mr. Tillis? Mr. Tillis, no. Mr. Toomey? Mr. Toomey, no. Mr. Tuberville? Mr. Tuberville, no. Mr. Van Hollen? Mr. Van Hollen, aye. Mr. Warner? Mr. Warner, aye. Mr. Warnock? Mr. Warnock, aye. Ms. Warren? Ms. Warren, aye. Mr. Whitehouse? Mr. Whitehouse, aye. Mr. Wicker? Mr. Wicker, no. Mr. Wyden? Mr. Wyden, aye. Mr. Young? Mr. Young, no. Mr. Graham? Mr. Graham, no. Mr. Paul. Mr. Paul, no.
On this vote, the yeas are 53, the nays are 47, and this nomination is confirmed. Under the previous order, the motion to reconsider is considered made and laid upon the table, and the President will immediately be notified of the Senate's action.
Madam President, very happily, I note the absence of a quorum.
The clerk will call the roll.
Ms. Baldwin.